The jury system is interesting to me in part because it's so old. I knew that it was an important institution in the early part of our country's history, and as I began to read more and more about it, I realized that it was also important in the colonies, that it was important in England at various times, going all the way back to the Middle Ages. So the book actually begins in the 12th century. And I was struck over and over again reading historical accounts, quotations from some of the original records that are kept in England, at how many similarities there were between the jury in medieval England and the contemporary jury in this way. Whenever there is a crime, or whenever there is a dispute between two parties, someone has to decide what actually happened. So that involves facts. And in the very beginning of the jury's history, jurors were people who were expected to know a little something about what was going on in town. This is a world of villages we're talking about. They would know, for example, which young man was more likely than some other young men to get into a scrape and pull a knife. They would know which farmer had some cows in his pasture that he couldn't account for, or who had been dishonest in the past. Facts. So the juror would have to know something about what was going on. The second thing that has to happen, always, is that someone has to figure out how to apply the law to those facts. Always, of course, the judge is the one who understands the law better than anyone else. But from the very beginning of the jury's history, the judge and the jurors were necessarily involved in a kind of partnership, sometimes willingly and sometimes unwillingly, but the judge would explain the law, the jurors would have to understand that law, and then they would have to try to apply it to the facts as they saw them. This inevitably places an enormous amount of power not in the hands of the government, but in the hands of the jurors. And so in colonial America, this understanding of the jury was very important. The jury is the popular branch of the judiciary. And so in Republican America, in Jeffersonian America, early 19th century America, the understanding was jurors understand the law because this is a free country and a democratic country. People make the law. They choose those who will write the law. Citizens can understand the law. If they can't understand the law, then a Republican form of government makes no sense. They can apply that law to the facts and come to their own conclusion, even if that conclusion is sometimes not the conclusion the judge would have come to. Now, even judges agreed that this was an appropriate understanding of the jury. Even some very conservative judges, Justice Chase, who was Samuel Chase, a famous Federalist judge, a high Federalist judge. Yes, he would say to the jury, you have the authority, you have the power to determine the law. I expect, of course, that you will understand the law as I give it to you, but you have the authority to make your own decision about the law. So the jury is old. It hasn't changed all that much over time. I can see some similarities between these medieval juries who would make up their own mind about what constitutes lawful self-defense, because the king was very fussy about who gets to kill somebody, and only the king can do that unless it's really self-defense. And the king's understanding of self-defense was sometimes much stricter than the jurors appreciated, and so they would find somebody not guilty of murder on the grounds of self-defense. And now we come to the Zimmerman case, the most recent controversial self-defense case. And it's basically the same problem. Here's the jury, here's the government. The government wants to put somebody in jail for murder. The jurors can't find it in the evidence to convict this person of murder, even if they don't like him very much. And so he's acquitted. So the power to make that decision lies in the hands not of the state, but of some sample of the public who has to make the decision. And that's true now, and it was true in the 12th century. Now, it's true that the jury has changed over time. And one of the themes that I looked at in this book was how those changes took place, why they took place, what their consequences are. So if I was to list them, I think I'd list them in this order. First of all, there has been a change in the toleration of the jury by litigants, particularly in civil cases. We have many fewer civil jury trials, and one of the reasons for that is that in the 20th century, really beginning in the late 19th century, there were a lot of complaints about whether civil juries could really understand the kind of complicated business cases that were now coming before the court. I mean, in the past, the classic civil cases, your cow tramples my fence, so I sue you for damages. Or in the 17th century, somebody has made an allegation about you being a witch, so you sue them for defamation. Now you've got, in the late 19th century, cases involving railroad accidents, automobile accidents, malpractice, medical malpractice in the 20th century. These are much more complicated cases, and so the critics of the jury system did say, in the past, jurors could understand these civil cases, but they can't now, and so they really need to be decided somewhere else. Late 19th century, early 20th century, this is an era when more and more Americans, particularly more and more American intellectuals, are becoming enamored of the idea of expert decision-making as a substitution for popular decision-making. Not just in the case of juries, but in a lot of cases. The administrative state is born, really, around the turn of the century. And the jury system is in some ways a victim of that distaste for public judgment in complicated cases. So one of the changes that we see, therefore, is a movement away from reliance on popular judgment, more and more reliance on experts, more and more reliance in the courts, for example, on judges making decisions about civil cases, settling them, pushing the litigants to arbitration instead of to a jury trial. So the jury's still there. It's always there in the background, kind of like the shotgun behind the door. And at the very last minute, parties will often settle rather than go to a jury trial. And they will say that the reason for this is they don't trust that the jury can really understand these complicated questions. Well, in the book, I discuss this and to the extent to which this is a reasonable judgment or not. I think sometimes it is. Some cases are pretty complicated. But there's a value, I think, nevertheless, in having the opportunity to put a difficult question to a popular judgment, especially since it won't necessarily apply to everybody in the same circumstance, because a trial deals with just one case. Over time, certain cases become common, certain kinds of decisions set precedents, but still each case is a little bit different. What is the responsibility of the cigarette companies, for example, for lung cancer? It took a long time to convince a jury that people who smoked didn't really know that smoking was bad for them. And after a while, litigants kind of gave up trying to get jurors to deal with the tobacco companies, and the country found other ways of doing that, health regulations and so on. So the jury's decision about a particular kind of civil question is not as powerful as it was in the past, but it's still there, and it's still available to people in the United States. It's been taken away from juries in England, Canada, Australia, New Zealand, throughout the Anglosphere, throughout the common law world, where civil juries were once important. they're virtually non-existent. They have survived only in the United States, but in a very limited and a kind of truncated way. On the criminal side, there's a similar decline in the percentage of cases settled by juries, even though, as in the case of civil trials, there's a whole lot more cases. I mean, one of the things that puts pressure on the jury system is the sheer workload of the courts, which has gone up by several 100% since the 1930s. Americans have always been very litigious. They're even more so these days, for various reasons, which I talk about in the book. It's easier to bring cases. It's less likely that those cases will be decided by juries. So the courts have more work. The court's resources have not increased as fast as the workload. So that's one pressure to not end cases with trials, but to end them before trials. On the criminal side, the same thing has happened. There was a huge increase in crime from the 60s through the 80s. Many more criminal cases in the state and federal courts. There are now many more federal crimes than there used to be. This is a federal government, a federal system. Most ordinary crimes in the past were state crimes. You had to be pretty imaginative to commit a federal felony. You could, if you committed a murder on an Indian reservation or on board a ship, that was a federal crime. It wasn't even a federal crime when Lee Harvey Oswald shot Jack Kennedy. Had he survived, he would have been tried in a state court for the murder of the President of the United States. Well, since the 60s, that's changed. There are now many, many, many more federal crimes. Owning an eagle feather, for example, is a federal crime. So the business of the federal courts on the criminal side has gone way up. Lots of complicated drug prosecutions, racketeering prosecutions. And in the 80s, the Congress decided that there were two things wrong with the way the courts, federal courts, were responding to this crime wave. One was that there was what was called sentencing disparities. You could get different punishments for the same crime depending on which federal district you committed the crime in. You might get sent to jail for 20 years for drug possession in Ohio, but only 15 years in New Jersey, let's say. So the Congress decided they wanted to have consistent sentencing across federal courts. And so the Congress came up with the idea of sentencing guidelines. The other complaint about the response to the crime wave was that many judges were giving hardened criminals a slap on the wrist, and so we had this opportunity for a bipartisan agreement. Conservative Republicans wanted longer sentences for serious crimes. Liberal Democrats wanted more consistent sentencing across jurisdictions, and so we ended up with the Sentencing Reform Act, which increased sentences so much that federal defendants now have a real incentive to plea bargain, much more so than they did in the past. So many fewer criminal cases go to trial, and many fewer, therefore, go to a jury. It used to be 20% of cases would plead. Now it's more like 20% of cases, would go to a jury trial. Now it's more like 10%, and it's going down even faster. So fewer and fewer cases go to trial, fewer and fewer cases that go to trial go to juries, and that's the extent to which the jury is vanishing from both the civil and the criminal side. And that's got a lot of people now concerned. So what difference does it make? Well, if it's true that, as our ancestors believed, the jury is the lower house of the judiciary, it's the popular branch of the judicial system, then the disappearance of the people's voice from the courts cannot be a good thing. If most criminal prosecutions, most civil judgments end up being made by judges and experts and not by the public, then first of all, the public's voice disappears from the courts. And secondly, the public loses a very important opportunity to learn the art of judgment. Now, this takes us back again to the very beginning of our history. In the 17th, 18th, and early 19th centuries, the jury was understood to be a way in which ordinary people could learn how to be a good citizen. And when you think about it, there are very few opportunities in a modern state for people to exercise judgment. We vote in elections, or at least 60% of us do. But voting in an election isn't a very difficult thing because basically you only have a choice of A or B. And a lot of people don't like either A or B, so they don't vote. The requirements for being on a jury, however, are much higher. The jury's task is much more difficult. The jury's task is to decide how to apply the law to a set of facts that the jury has found to be true beyond a reasonable doubt. And this is a form of judgment that actually requires a great deal of discretion, intelligence, judgment, integrity, and these were all things that the old jury laws asked of jurors. Those were the requirements, in a sense, for serving on a jury. So if we lose that ability for people to learn the art of judgment in this very difficult setting, then I think we've lost something very important. I'm not sure what the future of the American jury system is. At the moment, we are moving in the direction that other countries have moved in, although we won't go all the way. We won't actually abolish criminal and civil juries because that would require a constitutional amendment. And there's enough support for the jury system among the voters that that would never happen. But what we've accomplished, even without an amendment, comes very close to being the abolition of the jury system, since fewer and fewer cases are decided by jurors. If that continues to be the case, then the jury system will, in effect, wither and die. And there's another fear here that goes along with this. Because this isn't just something that applies to citizens, it also applies to judges and lawyers. Because there are fewer and fewer jury trials, there are fewer and fewer judges and attorneys who understand how to manage jury trials, how to talk to jurors, how to question jurors, how to argue before jurors. So these are skills that are disappearing from the legal profession as well as from the citizenry. So that's alarming. On the other hand, on the positive side, there are a lot of people who are worried enough about what's happened to the jury system that they have put it on the agenda, at least, as something to talk about when the question of the courts comes up. There is movement now also to rewrite the sentencing laws to make it a little bit harder to push people into plea bargaining, and that's probably a good sign also. So we'll see. I mean, I think this is now something that is understood to be a dangerous trend in a lot of quarters, and that's the beginning of trying to do something about it.